Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you, and what happened? Story 1. I had a hearing where the opposing party offered an updated contract that my client supposedly signed. Except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said, "I absolutely am, Your Honor. We won. Hands down. No further argument needed." Comment 1. Not a lawyer. I once had an individual accuse me of violating the Health Insurance Portability and Accountability Act, HIPAA. Sat at a meeting with hospital folks ready to give me the talk before the case moved forward. She started small talk and I said, "Can we please get to the matters at hand?" Then she starts, "Blah blah HIPAA blah blah me. Thank you. I fully understand the gravity of the accusation. Can you specifically outline why I cannot share this information with said individual?" Then she starts reciting nonsense hospital policy. I cut her mid-sentence and said, "Here is the document the patient signed that specifically outlines my ability to share this information with said personnel." Amazing how 3 checkpoints failed to look at the document, and there I was sitting in a meeting wasting time. She let me walk out after that, and told me that she'd take care of the situation. Felt like a total boss. I imagine you felt 100 times cooler after the "I absolutely am, Your Honor. Haha." Story 2. My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the estate due to de facto marriage. Our claim was that she was a gold digger who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates and times her and Dad proved their relationship with trips and combined spending, etc. She had so much evidence. The judge took 4 days to look it all over, after which he came back and basically said, "Why the hell would you have all of this if this wasn't your plan the whole time?" The case was very downhill from there. Edit. Some more clarification. She'd done the same thing to her ex-husband, giving precedent. He and her children said so in their testimonies. One of her children even inadvertently admitted she'd told them what to say and paid them for it. We were able to name the date the relationship between her and my dad ended, which was months before she claimed, and outside the time limit to make it a de facto or common law marriage. We had testimony from the doctor at his intensive care unit who said she tried to keep everyone, including his ex-wife, our mother, and us, his children, away from him. Meanwhile, she had his phone and computer and was trying to take over his contacts and business. We had proof of this. Her lawyer was incompetent, who constantly contradicted himself and the evidence. He lost documents, gave incorrect dates, and asked irrelevant questions of the defense. In the end, it was determined that her expenses for the relationship were deemed normal for anyone in any kind of romantic relationship, that gifts and meals aren't claimable for compensation, that her contributions to the household and business were not sufficient to warrant compensation. She never actually put any money into either, and that the relationship was not sufficient in duration to qualify as a common law marriage. This case took 4 years to settle, including 2 appeals. She finally gave up because she'd run into about $250,000 of court fee debt, as well as being forced to pay us $40,000. It ended with her refusing to concede, so the judge fined her $18,000, payable to us. She defaulted on this, so the judge raised it to $40,000. She was about to argue it, and the judge warned if she lost, it would be raised to $60,000. She paid the $40,000 and vanished. Story 3. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He got pulled over for playing the stereo too loud. There were pills in the center console, in a prescription pill bottle. The bottle had his mom's name on it. Client got arrested and charged with possession of a controlled substance without a prescription. The case was obviously weak, but the district attorney wouldn't dismiss. We went to trial. During closing arguments, the district attorney said, "This case is a circumstantial evidence case." During my closing, I slapped the jury instruction on the projector that said if a case is based on circumstantial evidence and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Edit. The jury instruction is Calcrim 224 if you want to look it up. Comment 1. A friend of mine was involved in a similar case. He had picked up his mother's car to take it for some service. Got stopped for rolling through a stop sign. Police officer spotted a handgun poking out from under the driver's seat. It was his mother's gun, legal and registered to her. My friend didn't know it was there. The officer arrested him for possession of the gun. After months of nonsense from the prosecutor, it was finally dropped. Story 4. Not a lawyer, but was taken to court once. A guy had taken my family to court basically because he had been dating my mother, and things ended. So he then took us to small claims court with an itemized list of everything he'd ever bought the entire family, every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had, and would always talk about his connections, and would name-drop someone anytime we went anywhere. So when he took us to court with his full itemized list, the judge asked him to go first and present his testimony. He basically said, "While I was with them, I bought all this stuff. I took them to dinner all the time and all this, but it was the idea it would be paid back by them." Judge: "You bought a child a birthday cake with the idea it would be paid back? Did you ever say that these things were loans and not gifts?" Him: "Well, no, but I shouldn't need to. That's the normal way people think." Judge: "Well, that's not the way I'd think." Case dismissed. Story 5. Not a lawyer, but took my brother-in-law's landlord to small claims court. He's on supplemental security income, and I'm his conservator. We sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not acceptable. He did, and that's why she kicked him out. I'm very organized and presented the judge with a folder containing photos, receipts, short videos on DVD, and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for, claiming that the apartment was trashed. There were holes in the walls, and they would have to repair everything before being able to rent again. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my brother-in-law's apartment obviously still being lived in. His stuff was all still there, and no visible damage, but there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where is the damage?" The son replied, "You can't see it. It's behind all of the posters." The judge frowned and looked at the video again, and then asked, "Did you take this video when he was still living there at this time?" The son replied, "Yes." This was the clincher. The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. We were awarded the full amount. Comment 1. I forgot to add that she also filed a temporary restraining order against him that we had to fight first. That landlord was a real piece of work. It was very satisfying when her son had to bring us a cashier's check for the judgment amount, or we could lawfully put a lien on her property. We just have the brother-in-law living with us now. Not the most preferred solution, but the easiest to facilitate on a day-to-day basis. Story 6. I had to go to court over a financial mistake when I was a student. Took advice from the university legal support team, who said I didn't need a solicitor, so I went in alone. The judge didn't like this and postponed it for another date so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said, "I didn't tell you this, but," and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right, went to the second hearing alone, and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about £9,000. Nice person. Story 7. Not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order, and 2 women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names, but you get the point. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom. Catherine Smith for 1 count of possession of a controlled substance with the intention to sell and 1 count of prostitution. So Catherine Smith stands up and indignantly cries, "Whoa, whoa, just wait a second. Where the hell did the prostitution charge come from? I may deal substances, but I am not a prostitute. Easiest case of dealing illegal substances my relative ever prosecuted. Story 8. Actual lawyer here. From the Fool for a Client file, was interning at legal services after my first year of law school, doing discovery work for family law. My supervisor invited us to observe a hearing for our client to get a restraining order against her husband. At the hearing, the client discussed various times he threatened her. The man representing himself interrupted and said, "Judge, I never said any of those things. If I had, she wouldn't be standing here." Restraining order granted. Story 9. Not a lawyer, but here's a story from the suburbs. My buddy is in the middle of a situation like that right now. His difficult neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek or natural drainage in between their yards. My buddy hired an attorney as the neighbor decided to sue him over it. My buddy's engineer that looked over the property noted, not only did my buddy set his yard up correctly, but the neighbor created drainage problems. The neighbor hired his own engineer, who proved my buddy was correct. Now the neighbor is likely to become even more difficult. The case was going to go to mediation. Since both engineers found fault with the neighbor, my buddy decided he's going to take it to trial. Turned the tables a bit. We'll post a follow-up if I can find this thread after the trial wraps. Story 10. My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he could lift up his arm after the accident. The witness made a feeble effort of lifting his arm. Then Jerry asked the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifted his arm much higher. The jury laughed. The case was over. Comment 1. Oh my, that is brilliant. I'm not a lawyer, but I assess people for physical capacity after workplace and vehicle accidents. My favorite trick, which this story reminds me of, is with clearly dishonest people reporting shoulder injuries in only one shoulder. I get them to lift both arms as high as they can at the same time. Because they are so focused on emphasizing how much they can't move the injured arm, they suddenly are hardly moving both arms, injured and uninjured. They get quite cranky when I say, "Hold on, there isn't anything wrong with your other shoulder. Why can't you move that one either? I'm going to try this guy's method and see what I come up with." Story 11. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual. But the defense didn't study their chemistry very well, and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry, did you mean carbon monoxide?" Because that's a completely different thing. Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel harmed his own case by not picking up a book. Edit. For clarification, this is not the only reason that lawyer didn't win. There were a lot of other things that didn't work out in his favor, but those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor, but it worked against him because he made a basic chemistry mistake that he honestly should have caught. Yes, I know he's not a scientist, but you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. Comment 1. This is indeed a major error. I'm a lawyer, and when something like this comes up, I read up on it, usually with the assistance of my own expert, and I'd like to think that I can hold an intelligent conversation with a subject matter expert on the specific issue we're actually fighting about. Over the years, that's been the case with various toxicology issues, accident reconstruction, eyewitness identification, various memory or recollection issues, a wide range of medical issues, and the list goes on. Problem is, somehow this information gets dumped into my short-term memory, and a week or a month later, after not having thought about it for that time, it's basically gone. I'd be a much smarter and more interesting person if I had retained all of it. Story 12. I worked as an intern for a lawyer. Construction law in France is quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As support, they kindly linked us to a 360-degree picture from said bell tower. We, as kindly, pointed out to them that our client's house was indeed not visible from the top of the church. Building permit was approved the following day. Story 13. Actual lawyer here, and this one was especially sweet, was involved in an ownership and control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough confusion to cause just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are, in effect, the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order, edited for spelling and to add the following, some background. The original Venezuelan High Court order, first order, created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States against an American company. The receivership was put in place by the shareholders and the Venezuelan government as the owner of the Venezuelan company. The previous owner was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claim to the federal court here in Miami that they were the only ones representing the company and that we were the imposters. They argued that the first order was not valid, and the previous owner was still in control of the company. There was a second order resulting from an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. The previous owner and his attorneys submitted the first and second orders as support to their motion. A third order was issued by a different Venezuelan appeals court, which put the issue to rest. We asked for and received a copy of it. They did not, either because they knew it was not supportive of their position or because they missed it. We believed it to be the latter. Our motions cited similar case law and advanced the same positions but were interpreting different orders. Story 14. A guy that I first used to work with was going through a messy divorce, about 20 years ago now. His soon-to-be ex-wife was very manipulative and her father was a psychologist, so he was pulling all the strings. He even had my coworker arrested at work one day, on false charges. The divorce case took years, one young son involved, and at every turn, my friend lost because of something the father filed or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was denied, and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case, and she said yes. The judge turned to my friend and said, paraphrasing, "Mr. Name, all these years and all these claims that I ruled against you." The court profusely apologizes. "I did not believe you, but now I do. Ruling in your favor," bangs the gavel. "I grant you full legal and physical custody of your minor child." Bailiff, please handcuff Ms. Name. My buddy was stunned that he won and happy at the same time. He later found out that the note said, "Give me my son or I'll kill you." Story 15 obligatory. I am not a lawyer, but I am a certified paralegal. I went to court and spoke for a friend at a hearing. I can ask questions to both parties and address the judge. The only thing I can't do is object to the other lawyer's line of questioning. So here's what happened. Best male friend was fighting a restraining order against him by his unstable ex-girlfriend. Everyone was in the courtroom that day, including her. Her lawyer questioned my friend about their relationship. As an aside, they lived together. He moved out and got his own place, but they were still together. She just got obsessively more unstable to the point where they broke up. She wanted some stuff back that she had gifted him, and he refused to let her in while not home to get it. She got very angry and made a scene in his front yard, getting police called and the neighbor's dog taken, for being a pit bull in a park where they were not allowed. Next thing you know, she's got a restraining order on his mom, who lived right next door to her son, and is trying to get one on him and sue him for his stuff back. So when he's on the stand, I'm questioning him about the incident, about her showing up and trying to break in. His mother called him the moment she saw her banging on the door, so he beat the police there. She had gotten in and was in the living room. I asked him if he was in fear of her, and he said absolutely, because upon walking in, she slid an iron bar from her sweatshirt sleeve, telling him to back off. He was just standing there, mouth open wide and shocked, cue her turn on the stand. I asked her about the day, if she had gotten in. She insisted she did via a key, which we knew was a lie. She never had a key. So then I asked her about the iron bar. Why did you have it? Where did it come from? My police officer friend gave it to me to protect myself while driving from road rage. It's in my car all the time, so I just brought it with me in case anyone was inside that wanted to mess with me. And did you have it up your sleeve? Yeah, because I didn't want neighbors to think I was breaking stuff. She was bawling and slamming her fists into her thighs and pulling her own hair, wailing. I rested after that. She admitted to trespassing while carrying a concealed weapon. Both restraining orders rescinded. She was asked to stay after court was adjourned, and the judge handed her mandatory therapy and committed her for observation. Story 16. Not a lawyer, but my parents were in a lawsuit where this happened. They owned a business, and on either side of it were businesses as well. Their neighbor to the left sued us, claiming that we had been using their property without paying them or without permission. That we were essentially trying to take ownership of it through adverse possession. We got a surveyor to come in, and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet. That was also our property. Obviously, they weren't happy, so they got their own surveyor, who gave us 50 feet. We won the lawsuit. Now their little patch of property has a rusty fence all around it with keep out signs everywhere. It's about 20 by 10 feet. Comment 1 reminds me of the time our neighbors were upset with the house we legally built. They claimed our retention wall caused them flooding. In actuality, they flooded all the time before we built. The county mandated we build the retention wall to alleviate their flooding. I even asked them which type of brick they preferred because they were the ones to have to look at it. Anyway, they were still upset and demanded a property line survey. Turns out, their fence encroached on our property by 2 feet. We demanded they remove the fence. While doing so, the neighbor came over and asked, "Can we just cut the posts? They're embedded in concrete, and that will increase our cost of removal." Nope. Remove the concrete too. Story 17. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel. Basically saying that the old lawyer didn't do his job. So we prepared an argument based on not asking the right questions, not communicating, etc. We thought it was going to be a tough case, but not unwinnable. Then we got the response to our complaint where the old lawyer argued that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The judge saw this, and during the trial we essentially asked, "Isn't this the definition of ineffective counsel? Not giving enough time to your client?" The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks, opposing counsel. I guess you were ineffective for both of you. Story 18. Not a lawyer but in a suit against an employee. Her attorney presented our contract and their contract to demonstrate the differences to prove that his client hadn't stolen ours. Then where did you get our contract? We won. Spent a couple $100,000. Defendants both ordered to pay $10,000, filed bankruptcy, and dissolved the business. Started anew with another competitor. Story 19. I am a lawyer, but this was from my time as a law clerk. Tattoo artist, around 40, got charged with harming an employee. The victim was 17, very fragile, and barely able to sit in the same room as the defendant. She stared at the table the entire time and you could barely hear her speak. She did not elaborate much on details, but basically he forced himself on her after closing the shop for the day. The defendant's story was that the employee came onto him and that it was consensual. The defense called a witness, another employee at the same shop, to basically tell everyone what a stand-up guy the defendant was. If I were to guess, I think the court was undecided but maybe leaning toward a not guilty verdict up until this point. The defense witness took the stand, started telling a story of how the defendant, while doing a tattoo on her, tried to hold her down and kiss her but had to stop because someone else came into the shop. Game over. The defendant was convicted, and a week later he declared that he was satisfied with the penalty and chose not to appeal. Story 20. Not a lawyer, but I am a former insurance fraud investigator. We were at a hearing before the Workers' Compensation Board. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem for me was that the video didn't get a clear face shot. Normally what we like to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer was prepping me and basically letting me know to be on point because the claimant's attorney was almost certainly going to challenge the fact that it was his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, the claimant's attorney agreed to stipulate to the fact that it was his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only defense they had. The claimant's attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer, since he was doing the roof incorrectly. He tried to get me to answer questions about roofing, but I refused, as it was beyond the scope of my work. And he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated numerous times and under oath that he cannot work. Whether he's doing it for free, for cash, or for fun has no bearing on the fact that he's doing roofing work while collecting compensation benefits which he was awarded because he couldn't do roofing work. The guy lost and had to repay a large amount of benefits. After a few of those hearings, I began forming a list of lawyers I would never hire and ones I would absolutely want on my side. Story 21. I am a lawyer. Sued a trucking company for underpayment of wages. They claimed they paid by route and not by the hour, despite doing their payroll by the hour, because they had a United States Postal Service subcontract that supposedly told them to pay by the route. The defense called the owner of the business to the stand and questioned her about the contract, which was clearly incomplete. She explained that the company gets a new subcontract every 4 years without fail. On cross-examination, I flipped to the first page of the contract and read the date, which was in the spring of Q. Did I read that correctly? A. Yes, Q. And you get a new contract every 4 years? A. Yes, Q. So you got a new one around the same time in A. Yes, Q. And why haven't you produced that contract today? A. I haven't seen it in years. But it's the same thing, Q. Where does this contract tell you to pay your drivers by the route? When she couldn't answer, I followed up with, and the contract that we don't have says the same thing. My client started working for them at the end of. Their whole argument was based on a contract they couldn't find. We won. Story 22. Oh, I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for a large amount of money. The guy showed up with a mountain of evidence, hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished this stuff like a weapon before court. My parents' lawyer thought he had a good case. Until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No. That's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started yelling at his client, "You said that was their tree." Case summarily dismissed. My parents walked out in shock, came home and bought me ice cream. All's well that ends well. Story 23. Not my case, but I was in the courtroom watching a trial. A defendant representing himself was accused of exposing himself to a guard and engaging in inappropriate behavior. As a pro se defendant, he defended himself at trial without an attorney. The prosecutor was doing well proving the case. When the female deputy was on the stand, the defendant asked her one question. "If you saw me do what you claim I did, then how big is my private part?" The deputy responded by raising her hands and estimating about 15 inches. The guy grinned, turned to the jury, nodded and said, "Yeah, that's right," and sat down. Obviously he was convicted. He was already serving about a 10-year prison sentence, so this conviction wasn't of much consequence, but I'll never forget it. Story 24. Accidentally proved? Not often. Made tactical errors. Often. I was arguing a case on a voter recount in front of a judge. The judge said, "I'm going with X." That was in my favor, so I shut up. Opposing counsel, while arguing a different point later, suddenly went back to the earlier point and kept talking about it. My client, who was also a lawyer, whispered to me, "Don't say anything." I whispered back, "Don't worry, wasn't planning to." The judge began rubbing his nose and looking irritated. After a few minutes, he cut off opposing counsel, saying, "I already ruled on this point." Then he asked me, "Anything to add, Mr. Smith?" I replied in the negative, and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easier for me? Absolutely. Story 25. My opposing counsel made some offhand remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the record-keeping process. In the jurisdiction we were in, records were an exception to the hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records, and won, all because the opposing counsel complained that their witnesses had to go out of their way to get records for the court. Story 26. Domestic violence case where the husband physically harmed the wife. The landlord tried to evict the wife for breach of lease due to the incident. The landlord claimed the wife violated lease terms by allowing police to be called to the property and causing a disruption. My argument was that as a domestic violence victim, the wife was covered under the Violence Against Women Act, and the property was federally subsidized. Also, Maryland law offers domestic violence protections too. The landlord's counsel, during his opening statement, talked about how my client was harmed and the police were called, along with an ambulance, etc. I just stood there looking at him. When he finished, the judge asked if I had anything to say. My response, "No, Your Honor, I believe opposing counsel has said everything that needs to be said." The judge smiled and ruled in my client's favor. The landlord couldn't evict a domestic violence victim. Story 27. My public defender wife, not a Redditor or I'd have her speak for herself, was trying a case where the defendant was accused of filling fraudulent prescriptions. Now keep in mind, public defenders deal with a lot of shady characters who maintain their innocence with increasingly implausible stories as the evidence gets worse. So you can get a bit jaded after a while, but you don't have to believe your client's story to represent them vigorously. So the prosecution had grainy surveillance video of someone who looked like the defendant filling the prescription and using the defendant's ID. The defendant maintained that someone stole his ID and was using it because they looked similar, but he had never reported the ID as stolen. My wife was skeptical that the jury would believe it, but she was always willing to go to trial if that's what the client wanted, so she prepared that defense and headed to trial. The prosecutor brought in the pharmacist who reported the prescription issue, went through the usual routine of establishing who she was, where she worked, whether this was the ID used that day, etc. Finally, the prosecutor asked the pharmacist if the person who attempted to fill the prescription that day was in the courtroom. No, oops. Story 28. Parents were being sued by their landlord, and my parents had a countersuit against him. They were moving across the country and found this house to rent. They did a walkthrough. It looked great. The landlord wanted first and last month's rent, a security deposit, and $1,500 because they had a dog and 2 cats. Fine. It was somewhere in the $8,000 to $9,000 range. No big deal for them. They were set to move in on a Monday, so my mom flew in on Saturday to do one final look-over, sign the contract, and get the key. Perfect. They were now the tenants. Monday, they arrived and the house was trashed. The landlord had moved a bunch of his stuff into the garage, shed, and one of the bedrooms. There was waste in the toilet, urine on the floor, garbage everywhere, and used items of a personal nature. My mom took pictures and videos throughout the entire house. She called the landlord and told him they were not moving in with the house in this condition. He told her to clean the house and he'd buy the first tank of heating oil. It was empty. He told her to do it or he'd keep all the money for breach of contract. A lot of back and forth happened, and there were tons of harassing texts and phone calls from him. Court day came, and everyone was ready to submit their evidence. My parents had photos, texts, the contract, and videos. The landlord only had the contract. But his contract was different than my parents'. He had included a section stating they permitted him access to the house for storage needs, and that the tenant was responsible for all on-site cleanup and maintenance after accepting the key. The best part was that the date of the signatures on his contract was the date they moved in, not the date my mom flew in and signed. The judge told the landlord he was a special kind of foolish, and then the judge's final remarks were about how disrespectful the landlord was for showing up in shorts, a Hawaiian shirt, and flip-flops in his courtroom. He never paid a dime, then claimed bankruptcy and started a business under a different name. 2 years later, I went to his house, let out all but 19 psi from all his tires, and superglued the caps on the valve stems. Story 29. My ex-girlfriend's father had a case where he brought in a decoy defendant. He then asked a key witness for the prosecution to identify the suspect in the middle of court. The witness turned and pointed to the decoy defendant, who was just a buddy of my ex-girlfriend's father and had nothing to do with the case. The witness was caught lying, and the whole thing was hilariously embarrassing for the prosecution. Turns out, even if you're right, it's a huge problem to trick witnesses like this. My ex-girlfriend's father had to go through an ethics investigation and was suspended from trying cases for a while. Story 30. My family did foster care for a few years, and we fell in love with the last girl we took in, now my younger sister. She was required to keep in regular contact with her emotionally and physically abusive birth mother, with the intention of eventually reuniting them. This woman was awful. Every single time they interacted, she'd spend the entire visit painstakingly tearing down my sister's self-confidence. My parents worked hard to establish a strong rapport and a supportive environment, and she blossomed under their care. She's one of the most resilient people I know. When the state tried to return her to her birth mother, she didn't want to go, so my parents sued for guardianship. This seemed like it would be an uphill battle. Here we were, a family of unrelated people trying to take a child from her biological mother. We were really afraid she would have to go back, and that her family would undo all the hard work she'd done rebuilding her self-esteem. Fortunately, her mother decided to represent herself at the guardianship hearing. I wasn't in the room, but I heard the audio recording later, and it's incredible how thoroughly this woman harmed her own case. Some highlights: she kept trying to testify while cross-examining people, for example. Would it surprise you to learn that blah blah blah? The judge called her out for this several times, and she just kept doing it. She admitted to various incidents of emotional abuse, but then tried to argue that it was justified because her daughter was being disrespectful. She'd ask witnesses, for example, "And wouldn't you be angry if your daughter did this? Yes or no?" My personal favorite and the best example of her proving our case: "It is absolutely not true that I hit my daughter with a wooden spoon. I only tried and missed. I'll prove it. I can show you the mark it left in the doorframe." Needless to say, we won guardianship. My sister never has to see that awful woman again, unless she chooses to.